The Minnesota Bureau of Mediation Services is commonly referred to as the BMS. This state agency is part of the executive branch of government and exists to promote stable and constructive labor management relations. In 1939, the state legislature enacted the Minnesota Labor Relations Act as a means of peacefully settling disputes resulting from the growing size and strength of Minnesota's labor movement. The act recognized that a sound economy is aided by constructive labor management environments. The mission of the Bureau of Mediation Services is to promote stable and constructive labor management relations and the use of alternative dispute resolution and collaborative process in areas other than labor management. The BMS was created to perform three essential functions. First, conciliation and mediation services. Second, arbitration. And third, representation, certification, and determination processes. The BMS provides neutral mediation of collective bargaining disputes. Such disputes arise over the negotiation of terms and conditions of a labor contract or result as an alleged violation of an existing labor contract. Mediation is a method of resolving disputes, a form of alternative dispute resolution in labor negotiations by employing a neutral third party, in this case a mediator, to assist the parties in reaching an agreement by maintaining communication and encouraging them to move towards a common goal. There are two types of mediation: contract mediation and grievance mediation. Let's take a look. Contract mediation usually starts when negotiations between the parties become non-productive or cease altogether. Grievance mediation occurs when there's a dispute over contract interpretation or employee discipline, which might otherwise be submitted to arbitration. Resolution of the grievance dispute through the mediation process tends to improve the overall climate of labor relations and avoids the financial costs and win-lose outcomes of arbitration. Now let's take a look at BMS arbitration, which provides neutral arbitrators to resolve contract and grievance disputes. Arbitrators meet rigorous standards of relevant labor relations experience, knowledge of collective bargaining, and arbitration. Arbitration is a method of resolving labor disputes, a form of alternative dispute resolution, by employing a neutral third party, in this case an arbitrator, to review the facts and make a decision that is binding on both parties. There are two types of arbitration: interest arbitration and grievance arbitration. In interest arbitration, the arbitrator intervenes in the process to resolve an impasse in labor negotiations. After an independent arbitrator is selected, both sides will submit their argument in writing to the arbitrator regarding their specific positions. The arbitrator then has 30 calendar days to submit a decision in writing to both parties. The decision is binding to the employer, the union, and to the employees. Grievance arbitration occurs during the life of the contract and results from an employee filing a grievance alleging that his or her rights, as specified in the labor contract, have been violated. The BMS also establishes groupings or units of employees which are appropriate for the purpose of collective bargaining and determines whether the employees within those groups desire to be represented by a labor union. An employee or labor organization may be eligible for certification as the exclusive representative for an appropriate unit by filing a written request with the Bureau of Mediation Services. The first formal step for a union or employee organization seeking to represent employees is filing a petition for certification of exclusive representation. Bureau procedure requires that a certification request contain the following: first, the petition for certification of exclusive representation. Second, providing a copy of the labor organization's constitution or bylaws. And third, filing valid authorization cards signed and dated by at least 30% of the employees within the proposed unit. The petition for certification of exclusive representation must be made in writing and include, first, other interested employee organizations or exclusive representatives. Second, whether there's a labor contract in effect and its expiration date. Third, the type of public employer involved. Fourth, the appropriate number of employees included in the proposed or previously determined appropriate unit. Fifth, the proposed or previously determined appropriate unit description. Sixth, confirmation of at least 30% of employees in the unit support the intent of the petition. 7th, the date the petition was signed, and finally 8th, the name and title of the person signing the petition. This petition contains a great deal of valuable information for a local government agency. When an agency receives information that a petition has been filed with the Bureau of Mediation Services, it should immediately contact the BMS and request a copy of the petition. In particular, the proposed bargaining unit and number of employees the union believes are in the proposed unit should be scrutinized to determine if the number of employees in the claimed bargaining unit is accurate. Upon receipt of a petition for certification of exclusive representation, an investigation and, if necessary, a public hearing will be held to review the request. If the proposed bargaining unit is found to be appropriate, an election will be conducted by the Bureau to determine whether eligible employees wish to be exclusively represented by the petitioning employee organization. In order to be certified as an exclusive representative, a majority of eligible employees who vote in the election must cast ballots in support of the petitioning employee organization. After a petition is filed with the BMS, the next step in union or employee organization seeking to represent a bargaining unit is to define the appropriate bargaining unit. MPELRA provides statutory criteria to use in determining what an appropriate bargaining unit is. The BMS must take into account that criteria and the following factors in determining whether positions belong together in a bargaining unit. They include positions covered by the same classification and compensation plan, positions in the same professions, skilled crafts, or other occupational classifications, relevant administrative and supervisory levels of authority, geographic location, history, extent of organization, recommendation of the parties, and other relevant factors. The law also provides some specific prohibitions against certain types of employees being placed together in the same bargaining unit. Essential and non-essential employees, as those terms are defined in MPELRA, cannot be placed in the same bargaining unit. This means that police officers, who are defined by state statute as essential, cannot be in the same unit with clerical staff, who are not essential as defined by the same statute. Additionally, supervisory and confidential employees cannot be included in the same bargaining unit as employees who are specifically not supervisory or confidential. However, supervisory and confidential employees may be included in the same bargaining unit. The primary reason for not mingling these essential and confidential employees with other employees is that essential employees have the right to binding arbitration in order to settle union contracts. Other types of employee groups must strike if they can't reach a settlement. All of the employees in the same unit need to have the ability to settle their contract and disputes in the same manner.